Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Bufkin v. Collins. In this case, the court considered this issue. Must the U.S. Court of Appeals for Veterans Claims ensure that the benefit of the doubt rule in 38 U.S.C. Section 5107b was properly applied during the claims process in order to satisfy 38 U.S.C. Section 7261b, 1? The case was decided on March 5, 2025. The Supreme Court held that the Department of Veterans Affairs' determination that evidence regarding a disability claim is in approximate balance is a factual determination subject to clear error review by the Veterans Court. Justice Clarence Thomas authored the 7-2 majority opinion of the court. The statute at issue, 38 U.S.C. Section 7261b, 1, requires the Veterans Court to take due account of the VA's application of the benefit of the doubt rule. This provision does not establish a new standard of review but instead directs the Veterans Court to review such determinations under the standards in Section 7261a, which provides for de novo review of legal questions and clear error review of factual findings. Determining whether evidence is in approximate balance involves both legal and factual components, as the VA must marshal and weigh evidence while also applying the legal approximate balance standard. Because this determination is primarily factual, clear error review is appropriate. Petitioners argued that the Veterans Court should review the approximate balance determination de novo, comparing it to judicial review of probable cause determinations, but this analogy is flawed. The probable cause inquiry involves substantial legal reasoning and constitutional concerns, whereas the VA's assessment of evidence balance is specific to each case and lacks broader legal implications. The statute's language does not support imposing de novo review, nor does the canon against surplusage justify a different reading. Justice Ketanji Brown Jackson authored a dissenting opinion, in which Justice Neil Gorsuch joined. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. When evaluating a veteran's claim for service-related disability benefits, the Department of Veterans Affairs, VA, applies a unique standard of proof known as the benefit of the doubt rule. This rule requires the VA to give the benefit of the doubt to the claimant whenever there is an approximate balance of positive and negative evidence on any issue material to the claim. When reviewing the VA's benefits decisions, the United States Court of Appeals for Veterans Claims, Veterans Court, must take due account of the VA's application of the benefit of the doubt rule. The question before us is what the Veterans Court must do to comply with that statutory command. We hold that the Veterans Court must review the VA's application of the rule the same way it would any other determination, by reviewing legal issues de novo and factual issues for clear error. And, we hold that the VA's determination that the evidence is in approximate balance is a predominantly factual determination reviewed only for clear error. Congress provides veterans a wide range of benefits, including compensation for disabilities caused or aggravated by active duty military service. The VA, led by the Secretary of Veterans Affairs, administers the laws that provide for those benefits. Veterans who suffer from service-connected post-traumatic stress disorder, PTSD, are among those entitled to disability benefits. To establish service-connected PTSD, the VA requires medical evidence diagnosing the condition and linking the veteran's symptoms with an in-service stressor, as well as credible evidence that the in-service stressor occurred. When the VA finds those conditions satisfied, it assigns a disability rating that reflects reductions in earning capacity. This rating determines the amount of compensation a veteran receives. A veteran begins the claims process by submitting a request for benefits to the Virginia VA Regional Office, then adjudicates the claim. If the regional office issues an adverse decision, the veteran may seek de novo review from the Board of Veterans' Appeals. The board is an administrative body within the VA that renders final decisions for the agency. Congress designed the VA's adjudicatory process to function with a high degree of informality and solicitude for the claimant. For example, Congress imposes no statute of limitations on a veteran's claim for benefits. The process at both the regional offices and the board is ex parte and non-adversarial. And, the VA must assist veterans in developing the evidence necessary to substantiate their claims. Congress also requires the regional offices and the board to give veterans the benefit of the doubt on close issues. Specifically, the VA must consider all information and lay and medical evidence of record, and, when there is an approximate balance of positive and negative evidence regarding any issue material to the determination of a matter, the VA shall give the benefit of the doubt to the claimant. This rule reflects a pro-veteran policy choice that dates back to the post-Civil War era. A veteran who receives an adverse decision from the board may appeal to the Veterans Court, an Article I tribunal. The Veterans Court has exclusive jurisdiction to review final decisions of the board. Section 7261 defines the scope of the Veterans Court's review. Subsection A which sets forth the court's adjudicatory powers, is modeled after the scope of review provision in the Administrative Procedure Act, APA. It empowers the Veterans Court to decide relevant questions of law, to compel action unlawfully withheld or unreasonably delayed, and to hold unlawful and set aside VA findings, conclusions, rules, and regulations that are arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. Unlike the APA, however, Section 7261A imposes a slightly different standard of review for factual findings. The Veterans Court may set aside or reverse a factual finding only if the finding is clearly erroneous, in contrast to the APA's substantial evidence standard. Subsection B sets forth additional requirements that the Veterans Court must follow in making the determinations under subsection A. As originally enacted, the provision required only that the Veterans Court take due account of the rule of prejudicial error. We have held that this statutory command requires the Veterans Court to apply the same kind of harmless error rule that courts ordinarily apply in civil cases. In 2002, Congress amended subsection B to add the provision at issue here. Codified at Section 7261B, 1, it directs the Veterans Court to take due account of the VA's application of Section 5107B of this title. In other words, when conducting judicial review under subsection A, the Veterans Court must take due account of the VA's application of the benefit of the doubt rule. In most cases, an appeal to the Veterans Court is a veteran's final opportunity for judicial review of a benefits decision. Although veterans may appeal certain legal issues to the United States Court of Appeals for the Federal Circuit, that court has held that it lacks jurisdiction to review most factual determinations, including whether the VA properly applied the benefit of the doubt rule in individual cases. Petitioners are veterans who applied for service-connected PTSD disability benefits and were dissatisfied with the VA's resolution of their claims. Petitioner Joshua Bufkin served in the Air Force from late 2005 to early 2006. Although Bufkin intended to join the military police, he never received a job assignment because he could not pass the required training classes. Bufkin blamed his poor performance on marital stress. He reported that his wife opposed his service and had threatened to commit suicide if he stayed in the military. Bufkin ultimately requested and obtained a non-prejudicial hardship discharge. 7 years later, Bufkin sought disability benefits from the Virginia HEN. He claimed that his military service caused several psychiatric conditions, including PTSD. To support his PTSD claim, Bufkin submitted a letter from a VA physician who had recently treated him. The physician explained that Bufkin's wife suffered from depression, and that Bufkin felt forced to make a choice between divorcing his wife or leaving the military. The physician diagnosed Bufkin with PTSD and opined that the primary stressor was the perceived threat to his wife's life. The VA regional office denied Bufkin's claim on the ground that the medical evidence was insufficient to establish a link between his symptoms and his military service. Bufkin sought reconsideration, and the VA ordered a second examination by a second VA physician. The new physician determined that Bufkin did not meet the criteria for PTSD. He explained that the first physician was unable to review Bufkin's military or medical records, a limitation that may have had a significant impact on Bufkin's initial diagnosis. Bufkin also submitted letters from his wife and mother describing changes they observed in his personality after his military service. The VA regional office reviewed the new information and reaffirmed its denial of Bufkin's claim. Bufkin filed a notice of disagreement. He argued that the evidence for and against his claim was roughly equal and that he was therefore entitled to the benefit of the doubt. Bufkin then underwent a third VA examination by yet another physician. Like the second physician, this physician concluded that Bufkin's symptoms did not meet the criteria for PTSD. She also noted that Bufkin's symptoms started 1 year after his discharge, and that no evidence indicated that his military service caused a disability. The VA regional office again reaffirmed its decision to deny benefits. Bufkin appealed to the board. While the appeal was pending, he submitted a short statement from a fourth physician. This physician stated that, in his opinion, Bufkin suffered from PTSD, but he noted other doctors might disagree with that diagnosis. He suggested that, at a minimum, Bufkin suffered from severe anxiety disorder. The board concluded that Bufkin did not suffer from PTSD and denied his claim. In a detailed opinion, the board recounted each physician's findings and medical conclusions. The board observed that one physician diagnosed Bufkin with PTSD, 2 physicians determined he did not have PTSD, and 1 physician thought the issue was debatable. After carefully reviewing each medical opinion, the board explained that it found the second physician's report especially persuasive. The board noted that the one physician to diagnose Bufkin with PTSD had not reviewed his military or medical records. The board also reviewed the letters from Bufkin's wife and mother but found that they lacked probative value because neither individual had relevant medical expertise. When taken as a whole, the board explained, the evidence was not in approximate balance. Accordingly, The board determined that Bufkin was not entitled to the benefit of the doubt. Petitioner Norman Thornton served in the Army from 1988 to 1991. After being honorably discharged, Thornton applied for and received benefits for an undiagnosed illness. Years later, he sought additional benefits for service-connected PTSD. The VA granted benefits for the PTSD claim, initially rating his condition as 10% disabling and later increasing the rating to 30%. In 2015, Thornton applied for another increase to his PTSD disability rating and underwent a new VA medical examination. The physician concluded that Thornton suffered some common PTSD symptoms, including depressed mood, anxiety, memory loss, and sleep impairment, but questioned whether PTSD was the cause of those symptoms. The physician did not find several of the more severe symptoms that earlier medical examinations had revealed, such as suicidal ideation, impaired impulse control, and panic attacks. Nevertheless, the regional office increased Thornton's PTSD disability rating to 50%. Thornton then sought an additional increase to 70% and underwent another medical evaluation, but the regional office maintained the 50% rating. Thornton appealed to the board, which reviewed the evidence de novo. As in Bufkin's case, the board thoroughly recounted each medical report and assessed the credibility of each physician's findings. The board ultimately declined to increase Thornton's 50% disability rating. Both petitioners appealed the board's resolution of their PTSD claims to the Veterans Court. They argued that the evidence concerning their diagnoses was in approximate balance, so they were entitled to the benefit of the doubt. In both cases, the Veterans Court upheld the board's decisions on the ground that the board's approximate balance determinations were not clearly erroneous. The petitioners then appealed to the Federal Circuit, challenging the Veterans Court's legal interpretation of the relevant statute. They argued that the statutory command to take due account of the VA's application of the benefit of the doubt rule requires the Veterans Court to review the entire record de novo and decide for itself whether the evidence is in approximate balance. The Federal Circuit rejected this argument and affirmed the Veterans Court in both cases. The court held that the statutory command that the Veterans Court take due account of the benefit of the doubt rule does not require the Veterans Court to conduct any review of the benefit of the doubt issue beyond the clear error review required. We granted certiorari to decide what it means to take due account of the VA's application of the benefit of the doubt rule. We start, as always, with the text. The relevant statute provides that in making the determinations under subsection A, the Veterans Court shall take due account of the VA's application of the benefit of the doubt rule. The plain meaning of the text reveals the scope of the Veterans Court's task. It is undisputed that the word shall imposes a mandatory command. Shall means must. It is likewise undisputed that to take account of something means to give it attention or consideration. The word due qualifies the attention that the VA must give. Due means appropriate or proper. Taken together, the statutory command to take due account of the VA's application of the benefit of the doubt rule requires the Veterans Court to give appropriate attention to the VA's work, at least when the issue is properly presented. The text makes clear that the appropriate attention due is that which is required under subsection A. The statute states that the Veterans Court must take due account of the VA's application of the benefit of the doubt rule only in making the determinations under subsection A. This language highlights that taking due account is not a freestanding task, but rather an aspect of judicial review under subsection A. The upshot is straightforward. Review of the VA's benefit of the doubt decision is just another determination made under subsection A. Accordingly, the standards of review provided in subsection A also govern the Veterans Court's review of benefit of the doubt issues. In particular, subsection A requires the Veterans Court to review the VA's conclusions of law de novo and its findings of fact for clear error. Which standard applies will depend on whether a veteran raises a legal or factual objection. Section 7261b(1) makes explicit the Veterans Court's previously implicit duty to review the VA's application of the benefit of the doubt rule, pursuant to the standards set forth in subsection A. Of course, this duty predated Congress's enactment of Section 7261b(1). Subsection A always required the Veterans Court to review all relevant findings of fact and conclusions of law, but Congress's enactment underscores the benefit of the doubt rule status as a paramount consideration. The next question, then, is the appropriate standard of review for challenges to the VA's application of the benefit of the doubt rule. The applicable standard will vary with the challenge, as the application of the rule has both factual and legal components. A veteran may challenge any aspect of the VA's application of the benefit of the doubt rule on appeal. No one disputes that challenges to the VA's legal conclusions are subject to de novo review. For example, if the veteran argues that the VA misunderstood the definition of approximate balance, the Veterans Court would construe the challenge as a legal one and review it de novo. So too if the veteran argues that the VA gave the benefit of the doubt to the wrong party. These arguments, however, are not the typical arguments a veteran raises on appeal. In mine-run cases, including the two before us, a veteran challenges the VA's determination that the evidence on a particular material issue is not in approximate balance. Petitioners assert that the approximate balance determination is a legal inquiry subject to de novo review. The government counters that the determination is a factual finding, or at least a mixed question that is predominantly factual and reviewed for clear error. After closely examining the way in which the VA conducts the approximate balance inquiry, we conclude it is a predominantly factual question and thus subject to clear error review. The approximate balance determination involves two steps. First, the VA reviews each item of evidence in the record and assigns weight to it. Both sides agree that this aspect of the VA's analysis is fact-finding reviewed only for clear error. Second, the VA assesses the weight of the evidence as a whole, deciding whether there is an approximate balance of positive and negative evidence on any material issue. The VA gives the benefit of the doubt to the veteran only after determining that the positive evidence and negative evidence on a material issue are in approximate balance. Otherwise, the VA simply resolves the issue in favor of the party with the more persuasive evidence. The second step, deciding whether the evidence as a whole is approximately balanced, has both legal and factual components. The task is partly factual because it involves marshalling and weighing evidence. The VA must categorize the evidence based on whether it supports or undermines the veteran's claim. After doing so, the VA compares the relative strength and persuasiveness of the evidence on each side. Assigning weight to evidence, whether individual pieces of evidence or collections of it, is an inherently factual task, but the VA's decision also involves a legal determination. After assessing the weight of the assorted evidence, the VA must decide whether the evidence is in approximate balance. The appropriate standard of review for a mixed question depends on whether answering it entails primarily legal or factual work. Some mixed questions require a court to expound on the law by amplifying or elaborating on a broad legal standard. When applying the law involves developing legal principles for use in future cases, appellate courts typically review the decision de novo. Other mixed questions require courts to resolve case-specific factual issues. When the tribunal below is immersed in facts and compelled to marshal and weigh evidence and make credibility judgments, the appellate court should usually review a decision with deference. Reviewing a determination whether record evidence is approximately balanced is about as factual sounding as any question gets. Consider Bufkin's case. To decide whether Bufkin was entitled to the benefit of the doubt, the board reviewed 4 medical opinions and 2 letters from Bufkin's family members. After assigning weight to each item, the board assessed whether the evidence was roughly equal. To make that determination, the board had to consider evidence of Bufkin's symptoms and their causes while assessing the credibility of the physicians who treated him. Thornton's case is no different. The board assessed the weight of his symptoms, the degree to which they affected his day-to-day life, and the credibility of each physician. These cases illustrate that the approximate balance determination necessarily immerses the board in case-specific factual issues. When that is so, that is, when the initial decision-maker is marshalling and weighing evidence and making credibility judgments, its work is fact-intensive, and its determinations should be reviewed with deference. Petitioners and the dissent offer various paths to a different result, but their arguments are not persuasive. First, petitioners urge us to hold that with one modest phrase, "take due account," Congress imposed a new standard of review for challenges to the VA's application of the benefit of the doubt rule. Before the Federal Circuit, petitioners argued that Section 7261b(1) established a de novo standard of review. They hesitate to call the standard de novo review before this court, instead describing it as APA+. However labeled, the directive to take due account does not do the work that petitioners envision. Had Congress intended to impose a new standard of review for challenges to the VA's application of the benefit of the doubt rule, it would have clearly named a standard, just as it did in Section 7261A. But, as we have explained, Congress chose not to announce any new standard in Section 7261b(1). It instead incorporated the pre-existing standards of review set forth in subsection A. Petitioners contend, in the alternative, that even if Section 7261b(1) incorporates the standards of review in Section 7261A, the VA's approximate balance determination is a legal question subject to de novo review under Section 7261A. The dissent adopts a similar view, arguing that the approximate balance determination is a predominantly legal mixed question. The de novo standard applies, they say, because the approximate balance determination resembles other legal or predominantly legal questions that courts review de novo. They point to judicial review of a court's probable cause determination as one such analog. Probable cause is the standard by which a court assesses whether a police officer's search or seizure was permissible under the Fourth Amendment. For example, probable cause to search exists where the known facts and circumstances are sufficient to warn a man of reasonable prudence in the belief that contraband or evidence of a crime will be found. We have held that this inquiry is a mixed question that courts review de novo. Two features of the probable cause determination distinguish it from the approximate balance determination, however, and underscore why courts review it de novo. First, because probable cause is a constitutional standard, we start with a strong presumption that determinations under that standard are subject to de novo review, even if they require courts to plunge into a factual record. Second, probable cause at bottom poses a question that requires substantial legal work. Because probable cause asks whether the officer's understanding of the facts and his understanding of the relevant law was reasonable, it requires an objective, legally grounded inquiry as to what a hypothetical person could have found. The answer to how a hypothetical person would act is, by its nature, one that courts refine over time, building out principles that acquire content only through application. De novo review is therefore essential so that courts can ensure uniform precedent that will provide law enforcement officers with a defined set of rules which, in most instances, makes it possible to reach a correct determination beforehand as to whether an invasion of privacy is justified. The VA's approximate balance determination differs on both counts. First, the standard is a creature of statute. Because it does not dwell in the constitutional realm, it is not entitled to the presumption of de novo review that applies to probable cause. Second, the approximate balance inquiry does not have a comparable legal component. Instead, as these cases exemplify, that inquiry tends to be case-specific and fact-intensive, with courts evaluating the weight of the evidence for and against a particular veteran's claim. To decide Bufkin's claim, for example, the VA reviewed a panoply of medical and lay evidence, and Bufkin's central argument before the Veterans Court was that the overall balance of this evidence was closer than the VA thought. Thornton's claim similarly presented case-specific, fact-bound issues about the existence and severity of symptoms. Resolution of these claims is unlikely to generate guidance for the VA or future courts in the way that probable cause precedents do for police and the courts. The VA's approximate balance determination is likewise distinct from a court's conclusion that evidence is sufficient to support a criminal conviction, a conclusion that courts review de novo. While the sufficiency of the evidence inquiry necessarily turns on facts, the reviewing court does not decide for itself whether the evidence establishes guilt beyond a reasonable doubt. Instead, it construes all evidence and makes all reasonable inferences in favor of the prosecution, and asks whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Courts therefore conduct their review through a legal lens, applying a hypothetical, objective standard and putting a thumb on the scale in favor of the prevailing party, the prosecution. No one, petitioners and the dissent included, wants the Veterans Court to do that. Instead, petitioners and the dissent would have the Veterans Court weigh the evidence in the first instance, and then make inferences from basic facts to ultimate facts, precisely what a court may not do on sufficiency review. Petitioners and the dissent also rely heavily on the assertion that our reading of Section 7261b, 1, renders the provision superfluous. That objection is a serious one. We are reluctant to treat statutory terms as surplusage in any setting. Our reluctance increases when Congress amends a statute, as we ordinarily presume that when Congress does so, it intends its amendment to have real and substantial effect. But our reading of Section 7261b, 1, gives that provision a function, even if it might involve some redundancy. As we have explained, Congress's amendment makes express the Veterans Court's obligation to review challenges to the VA's application of the benefit of the doubt rule according to the standards set forth in Section 7261a. Moreover, as the dissent notes, we have left open the possibility that Congress's enactment requires the Veterans Court to review the VA's application of the benefit of the doubt rule even if the veteran fails to present that issue on appeal. If the court were to decide that Congress's enactment changed the party presentation requirement, then the enactment of Section 7261b, 1, would serve an additional independent function. Notably, the dissent fails to offer a reading of the text that avoids redundancy. According to the dissent, the VA's approximate balance determination is a predominantly legal question subject to de novo review. But if the dissent were correct, then the approximate balance determination would have been subject to de novo review even before the enactment of Section 7261b, 1. All agree that under Section 7261a, which predated Congress's enactment of Section 7261b, 1, the Veterans Court is required to review questions of law de novo. Thus, under the dissent's interpretation, no less than ours, the enactment of Section 7261b, 1, merely underscores a pre-existing duty. The canon against surplusage can be meaningful when a competing interpretation would avoid superfluity, but when both interpretations involve the same redundancy, the canon against surplusage simply does not apply. In any event, sometimes the better overall reading of the statute contains some redundancy. Here, the text leaves no doubt that the Federal Circuit's reading of the statute is the better one. Section 7261b, 1, does not establish a new standard of review for challenges to the VA's application of the benefit of the doubt rule. Instead, it requires the Veterans Court to apply the appropriate standard of review under Section 7261a. Because the VA's approximate balance determination is a predominantly factual question, the Veterans Court reviews it for clear error. The judgment of the Court of Appeals is affirmed. It is so ordered. Justice Jackson, with whom Justice Gorsuch joins, dissenting. The Court draws two conclusions from today's evaluation of Congress's take due account admonition. First, it holds that when the United States Court of Appeals for Veterans Claims, Veterans Court, reviews the Department of Veterans Affairs, VA's, application of the benefit of the doubt rule, that appellate tribunal must use the same standards of review that apply to its assessment of any other VA claims determination. Second, the Court concludes that whether evidence is in approximate balance for purposes of the benefit of the doubt rule is a predominantly factual determination to be reviewed only for clear error. The majority is wrong in both respects. Nothing about the text, context, or drafting history of subsection B1 demonstrates that take due account actually means proceed as normal. Reading the provision in that fashion, as the majority does, makes little sense. That interpretation is also inconsistent with how we have treated identical language elsewhere in this same statute, and renders meaningless the take due account command that Congress specifically amended Section 7261b to insert. The majority's clear error conclusion fares no better, insofar as its reasoning ignores what appellate courts do and what we have consistently said about substantially similar circumstances. That is, even if the majority were correct, that subsection B1 instructs the Veterans Court to carry on applying the usual standards, clear error review would not be appropriate because whether the VA properly applied the benefit of the doubt rule does not present a question of fact. The VA's benefit of the doubt determination poses, at most, a mixed question of law and fact, and one that is substantively indistinguishable from the kinds of mixed questions that this Court has long said are subject to de novo review on appeal. In short, the Court today concludes that Congress meant nothing when it inserted subsection B1, in response to concerns that the Veterans Court was improperly rubber-stamping the VA's benefit of the doubt determinations, and also that the Veterans Court is not obliged to do anything more than defer to those agency decisions notwithstanding Congress's take due account direction. I respectfully dissent. Under the time-honored benefit of the doubt rule, veterans asserting claims for service-connected disabilities are entitled to have any reasonable doubt on a material issue resolved in their favor. Congress codified this rule in 1988. Section 5107B of Title 38 states unequivocally that the VA must give the benefit of the doubt to the claimant whenever there is an approximate balance of positive and negative evidence regarding any issue material to the veteran's benefits claim. This generous standard of proof honors the sacrifices of those who have served in the armed forces. Recognizing the weighty interests at stake in cases that involve benefits for veterans, Congress's 1988 legislation also established judicial review of the VA's benefits decisions by the Veterans Court, a specialized Article I tribunal. Section 7261a lays out in detail the authority that the Veterans Court has been given. As relevant here, the Veterans Court is authorized to 1. Decide all relevant questions of law, 2. Compel action of the Secretary unlawfully withheld or unreasonably delayed, and 3. Hold unlawful and set aside certain VA decisions. Notably, Clause 4 of Section 7261a states that in the case of a finding of material fact adverse to the claimant made in reaching a decision in a case before the VA with respect to benefits, the Veterans Court shall hold unlawful and set aside or reverse such finding if the finding is clearly erroneous. For present purposes, all parties agree that Section 7261a has always authorized the Veterans Court to review the VA's application of the benefit of the doubt rule. But judicial review of that issue proved illusory from the start, because the Veterans Court historically applied a deferential standard of review for assessing the VA's benefit of the doubt determinations. As a result, veterans groups routinely complained to Congress that judicial review by the Veterans Court was inappropriately deferential. Congress responded in 2002, when it amended Section 7261b to specifically require the Veterans Court to take due account of the VA's application of the benefit of the doubt rule. In its entirety, the amended subsection B states: B. In making the determinations under subsection A, the Veterans Court shall review the record of proceedings before the Secretary and the Board of Veterans' Appeals, and shall 1. Take due account of the Secretary's application of Section 5107B of this title, and 2. take due account of the rule of prejudicial error. The plain text of Section 7261b, 1, thus requires the Veterans Court to take due account of the VA's obligations under the benefit of the doubt rule when it reviews VA benefits determinations under Section 7261a. The dispute before us concerns the meaning of subsection B1's take due account clause. The majority and I agree that subsection B1 imposes a statutory command that the Veterans Court give appropriate attention to the VA's work related to its application of the benefit of the doubt rule. But the majority concludes that the appropriate attention due is that which is required under subsection A. In my view, that holding is unmoored from subsection B1's text, ignores Section 7261's overall structure and drafting history, and renders entirely superfluous Congress's requirement that the Veterans Court take due account of the application of the benefit of the doubt rule. The better reading of the statute recognizes that subsection B1 requires the Veterans Court to determine, without deference, whether the VA properly applied the benefit of the doubt rule. The primary textual pillar of the majority's conclusion that review of the VA's benefit of the doubt decision is just another determination made under subsection A is its observation that subsection B1's review applies only in making the determinations under subsection A. Based on that prefatory language, the majority reasons that subsection B1 is merely an aspect of the review that the Veterans Court performs under subsection A, such that the standards of review provided in subsection A also govern the Veterans Court's review of benefit of the doubt issues, but the fact that the Veterans Court must apply subsection B1 in making the determinations under subsection A does not justify collapsing these two provisions. The word in, when paired with a gerund, here, making is generally equivalent in sense to a temporal clause introduced by when, while, if, or in the event of. The in-making clause in subsection B thus merely provides that when the Veterans Court makes one of the determinations authorized by subsection A, it must also satisfy its duty to take due account of the VA's application of the benefit of the doubt rule. In other words, the in-making clause the majority seizes upon to justify its same standards holding simply establishes that review under subsection B1 occurs alongside review under subsection A, not that they are the same thing. Interpreting subsection B1 to require a separate, concurrent review of the VA's compliance with the benefit of the doubt rule is consistent with how this court has interpreted subsection B1's parallel provision, subsection B2. Subsection B2 directs that, in making the determinations under subsection A, the Veterans Court shall take due account of the rule of prejudicial error. In a prior decision, we held that subsection B2 requires the Veterans Court to apply the same kind of harmless error rule that courts ordinarily apply in civil cases. We did not suggest, much less hold, that subsection A's standards of review govern subsection B2's take due account clause. To the contrary, we explained that the Veterans Court is not prevented from directly asking the harmless error question and resting its conclusion on the facts and circumstances of the particular case. Thus there is no dispute that, under subsection B2, the Veterans Court analyzes whether any error was harmless de novo, without applying the standards of review prescribed by subsection A, and because subsection A's standards do not apply when the Veterans Court takes due account of the rule of prejudicial error under subsection B2, it is oddly discordant for the majority to conclude that those standards do apply when the Veterans Court takes due account of the Secretary's application of the benefit of the doubt rule. Identical words and phrases within the same statute should normally be given the same meaning. An understanding of how subsection B2's take due account language functions in practice further clarifies subsection B1, as subsection B2 existed prior to subsection B1, and plainly served as its model. The majority does not dispute that the VA's appellate tribunal, the Board of Veterans' Appeals, sometimes applies the rule of prejudicial error in the first instance. If the board determines that an error was harmless and denies a veteran's claim, then per subsection B2, the Veterans Court reviews the record for prejudicial error and does so de novo, in other words, without any deference to the board, before affirming. Subsection B1 works in precisely the same way. If the Veterans Court is inclined to affirm the VA's denial of benefits, subsection B1 requires it to first confirm de novo that the benefit of the doubt rule was properly applied. Nor does the drafting history of the relevant provisions support the majority's contention that subsection B1 is an aspect of subsection A, or that subsection A4 substantively limits the review that subsection B1 requires. In fact, the historical account suggests the opposite. The initial Senate bill amended subsection A4 rather than subsection B to command that the Veterans Court take into account the VA's application of the benefit of the doubt rule. That bill also proposed two other relevant changes. It authorized the Veterans Court to reverse the VA's factual findings rather than remand them, and it eliminated the clearly erroneous standard of review. Accordingly, under the Senate's bill, subsection A4 would have authorized the Veterans Court to set aside or reverse any factual finding of the VA that was unsupported by substantial evidence of record, taking into account the Secretary's application of the benefit of the doubt rule. Had Congress adopted this proposal, the majority's conflation of subsections A and B1 might stand on firmer ground, but Congress plainly rejected that approach. It instead amended subsection A4 only to empower the Veterans Court to reverse certain factual findings, i.e., those that are material and adverse to the claimant, and neither modified subsection A4's clear error standard nor inserted a requirement that the Veterans Court review the VA's application of the benefit of the doubt rule into that provision. At the end of the day, then, instead of incorporating a benefit of the doubt rule reminder into subsection A4, Congress crafted an entirely new statutory provision, subsection B1, to address judicial review of the VA's application of the benefit of the doubt rule. Recognizing that review under subsection B1 is distinct from review under subsection A4, respects Congress's choice to separate those two provisions. It also comports with subsection B1's language and the statute's overall design. No one disputes that Congress sought to subject the VA's benefit of the doubt decisions to increased judicial scrutiny while otherwise preserving the VA's not clearly erroneous factual findings. Reading subsection B1 to be such a congressional mandate furthers that objective, while the majority's conclusion that subsection B1 implicitly incorporates subsection A4's limited clear error standard undermines it. The usual indicators of statutory meaning thus confirm that subsection B1 was meant to have bite, but the majority's reading renders it toothless. According to the majority, subsection B1 does not impose any new obligation on the Veterans Court. Instead, that provision merely underscores the importance of Section 5107B's benefit of the doubt rule. At oral argument, the government put the matter even more bluntly, arguing that subsection B1 is an exclamation point that does duplicate work and is ultimately redundant. This interpretation, which the majority adopts, violates the cardinal principle of statutory interpretation that courts ordinarily give effect, if possible, to every clause and word of a statute. The majority acknowledges that the surplusage argument is a serious one and that its interpretation might involve some redundancy. Still, the majority maintains that subsection B1 has a function even if it performs zero independent work. That is because, as the majority sees it, subsection B1 makes express the Veterans Court's duty to hear challenges to the VA's application of the benefit of the doubt rule under subsection A, and may even require the Veterans Court to do so sua sponte. But the majority cannot overcome the surplusage problem simply by asserting that subsection B1 emphasizes or clarifies a pre-existing duty. To state the obvious, most superfluous language can be justified as providing clarity. Perhaps for this reason, the majority does not identify any other case in which this court held that Congress passed an amendment with no substantive effect. Moreover, the majority does not and cannot explain why any such expression of the Veterans Court's duties was needed, much less why Congress would go out of its way to amend the statute to underscore an existing obligation. Subsection A covers the waterfront of possible exercises of judicial authority and has always required the Veterans Court to consider any argument presented by a veteran. Subsection A cannot be reasonably read to exclude consideration of a veteran's claim that the VA misapplied the benefit of the doubt rule. And no one actually thought this. Indeed, prior to Congress's enactment of subsection B1, the Veterans Court regularly considered challenges to the VA's application of the benefit of the doubt rule. It just did so deferentially. Thus, the problem that Congress enacted subsection B1 to address was not that the Veterans Court seemed to have limited authority under subsection A, nor was it that the Veterans Court was somehow unaware of its duty to review the VA's application of the benefit of the doubt rule upon request. Rather, as I have explained, Congress enacted subsection B1 after veteran service organizations brought to its attention how the Veterans Court was performing that review, i.e., it was giving too much deference to the VA's benefit of the doubt determinations. Congress's indisputable focus was on the improper degree of deference the Veterans Court was affording to the VA's determinations, a target that the majority's reading misses completely. Finally, the majority maintains that if Congress had intended for subsection B1 to do anything other than underscore the pre-existing duty to consider challenges to the VA's benefit of the doubt determinations, it would have more clearly said so. That gets things exactly backwards. Ordinarily, when Congress amends a statute, We presume it intends its amendment to have real and substantial effect. The majority instead presumes that Congress intended to enact a do-nothing amendment. But if Congress had wanted to maintain the status quo, why enact subsection B1 at all? The presumption is, and should be, that Congress expects a change when it goes through the trouble of amending a statute. And, here, the majority's reasoning has plainly failed to overcome that presumption. The Veterans Canon resolves whatever lingering doubt might remain about the proper interpretation of subsection B1. We have long applied the canon that provisions for benefits to members of the armed services are to be construed in the beneficiary's favor. Likewise, under the Veterans Canon, interpretive doubt is to be resolved in the veteran's favor. The Veterans Canon strongly supports interpreting subsection B1 to represent more than Congress's grandiloquence. Requiring subsection B1 to effect the judicial review the Veterans Court provides aligns with the significance of the benefit of the doubt rule and mitigates the unique problems that arise in veterans' cases, including that veterans are often unrepresented before the Virginia veterans' claims also often involve a considerable time lag that produces problems of proof, since no statute of limitations applies to such claims. An appeal to the Veterans Court is generally a veteran's final opportunity to correct the VA's mistakes. Non-differential review of the VA's benefit of the doubt determinations plainly minimizes the risk that veterans with borderline claims will be denied benefits to which they are entitled. Therefore, the Veterans Canon garnishes an already solid argument based on the statute's text and structure. Reading subsection B1 as a standalone command that requires the Veterans Court to review the VA's application of the benefit of the doubt rule non-differentially obviously favors veterans more than an interpretation that reduces the provision to an exclamation point. The majority does not stop at the mistaken conclusion that Congress enacted subsection B1 for no reason other than to reiterate the Veterans Court's pre-existing statutory duties. It also proceeds to analyze how a challenge to the VA's application of the benefit of the doubt rule fares when filtered through the authority conferred to the Veterans Court in subsection A. In this regard, the majority reasons that part, but not all, of the VA's application of the benefit of the doubt rule must be reviewed for clear error. But in my view, the Court mischaracterizes the approximate balance assessment under Section 5107B, which is the part of the analysis that is at issue here. The majority maintains that aspect of the benefit of the doubt rule involves the type of predominantly factual finding that appellate courts ordinarily review with deference. Stated simply, such is not the case. To understand the majority's mistake, one must first be clear-eyed about the two steps that are necessary for the Veterans Court to review the VA's application of the benefit of the doubt rule. First, the Veterans Court identifies and reviews the VA's relevant factual findings concerning the evidence presented. Then, the Veterans Court determines whether, based on the VA's plausible factual findings, the positive and negative evidence is in approximate balance, what I call the approximate balance standard. All agree that the clear error standard applies to the VA's factual findings regarding the evidence that the Veterans Court examines at Step 1. So, for example, the Veterans Court must accept the VA's determination that a particular piece of evidence is reliable, or that an individual medical examiner is qualified, unless those findings are clearly erroneous. It is at the second step, when the Veterans Court determines whether the evidence is in approximate balance, that questions of law come in. At Step 2, the Veterans Court is essentially being asked to decide whether a legal standard, approximate balance, has been satisfied on the established facts. As a general matter, this court has long treated the application of a legal standard to a given set of facts as an exercise that poses a legal question. What the majority misses in its effort to shoehorn Section 5107B's approximate balance inquiry into the question of fact category is the true nature of that assessment, as well as the fact that making the approximate balance determination is more nuanced than simply weighing the evidence on hand. For one thing, the court must have a standard for deciding when the evidence before it is in approximate balance as a matter of law. In our common law legal system, devising that standard happens over time, on a case-by-case basis. Therefore, applying it might well involve examining Veterans Court precedents concerning the meaning of approximate balance, as well as past cases that establish when and under what circumstances certain kinds of evidence will be found to qualify. One can easily imagine a body of case law developing to illuminate the substantive and procedural contours of the approximate balance inquiry and the factors that are to be considered. Thus, applying Section 5107B's approximate balance test is in no way akin to finding a material fact that is ultimately subject to subsection a 4S clear error review, as even the government appeared to concede at oral argument. Rather, application of the approximate balance test presents a classic mixed question of law that requires applying a legal standard to historical facts. Where Congress has not prescribed a standard of review for evaluating a mixed question, The appropriate degree of deference reflects the nature of the mixed question and which kind of court is better suited to resolve it. In general, trial courts' expertise as fact-finders justifies deference to their factual determinations. For this reason, appellate courts usually review with deference mixed questions that require resolving case-specific factual issues. But, as I have already explained, that is not what is happening here. Even if the majority is correct to assume that Section 5107B's approximate balance standard calls for a mere head-to-head weighing of the positive and negative evidence, that is still an insufficient basis upon which to rest the majority's clear error conclusion, because deference is not always given regarding such fact-specific inquiries. There are circumstances where de novo review is appropriate even when answering a mixed question primarily involves plunging into a factual record. Consider one common example. Whether probable cause existed to support a search or seizure in the Fourth Amendment context is a mixed question of law and fact that appellate courts review de novo. And review of probable cause determinations proceeds in two steps, just like the approximate balance inquiry. At step 1, the appellate court identifies the relevant historical facts and reviews them for clear error. At step 2, the court decides whether an objectively reasonable police officer would believe that those facts establish probable cause to search. The second step is a legal question that asks whether the facts satisfy a legal standard. Another highly fact-sensitive inquiry is whether evidence presented at trial is sufficient to support a verdict, and appellate courts review that determination de novo as well. In a civil case, the trial court may grant judgment to a moving party as a matter of law after the non-moving party has been fully heard on an issue during a jury trial, if it finds that a reasonable jury would not have a legally sufficient evidentiary basis to find for the party on that issue. When making this decision, the trial judge determines whether, reviewing the facts in the light most favorable to the non-movement, the evidence is sufficient to meet the applicable evidentiary standard. And, on appeal, the reviewing court undertakes the same sufficiency analysis by evaluating the evidence without any deference to the trial court's determination. These examples demonstrate that non-differential appellate review of fact-bound legal issues is not unprecedented, and under Section 7261B, 1, the Veterans Court must follow suit. Section 7261B, 1, directs the Veterans Court to evaluate the VA's approximate balance decisions by first accepting the agency's not clearly erroneous factual findings about the evidence presented, and then determining whether that evidence satisfies the approximate balance standard, without deference to the VA's own conclusions. This analysis, which is both legal and factual components, is plainly analogous to the sufficiency of evidence and probable cause questions that appellate courts regularly review de novo. The majority dismisses these compelling parallels on the grounds that assessing the sufficiency of the evidence or determining the existence of probable cause are more legal than the approximate balance inquiry. The majority further emphasizes that evaluating whether the evidence is approximately balanced for Section 5107B purposes is a fact-intensive inquiry that is better left to the tribunal below than the appeals court. It also unfurls a surplusage argument of its own. If de novo review applies to the VA's approximate balance determination, the majority says, then subsection B1 is superfluous under petitioner's interpretation because that determination would have been subject to de novo review even before the enactment of Section 7261B, 1. None of this reasoning is persuasive. To start, the majority's efforts to distinguish sufficiency and probable cause review from the approximate balance inquiry fall flat. For example, according to the majority, the probable cause inquiry is distinguishable because reviewing courts assess probable cause from the standpoint of an objectively reasonable officer, and courts are required to consider and refine over time what a hypothetical person would deem reasonable as a matter of law. The majority says that sufficiency challenges likewise require courts to use a legal lens, applying a hypothetical, objective standard i.e., what a reasonable jury could find. But the approximate balance inquiry is not meaningfully different. Before the Veterans Court can determine whether the VA erred in deciding that the positive and negative evidence is not an approximate balance, it must first have an understanding of what balanced evidence looks like in this context. Identifying balance might involve a hypothetical and objective examination of the evidence, just like a review of the sufficiency of the evidence or probable cause. Imagine two doctors testify in favor of a claimant's diagnosis and two doctors testify against it. Does the mere fact that the same number of witnesses are presented on both sides mean that the evidence is balanced, as a legal matter? The Veterans Court would need to develop a legal rule to decide. It would also need to decide how the quality of the evidence factors in. What if one of the doctors is the Nobel laureate who discovered the condition at issue while others are recent medical school graduates? Does the testimony of a doctor who has examined the claimant balance evenly against one who has not? It is thus quite likely that legal standards will need to be developed to govern the assessment of approximate balance, which is why the majority is wrong to contend that resolving approximate balance challenges will rarely produce generally applicable precedents. Regardless, the mere fact that the assignment here involves a fact-intensive and multifaceted decision, such that one determination will seldom be a useful precedent for another, should not impede our recognition of the significant questions of law that are embedded in the application of the approximate balance standard. The majority's attempt to distinguish probable cause from the approximate balance standard because the latter is a creature of statute is similarly off base. To be sure, application of the benefit of the doubt rule is not constitutional in nature. But this principle is not a mere statutory creation, either. It predates Section 5107B and in fact dates back to the post-Civil War era. In any event, the majority does not explain why the statutory versus constitutional distinction has any rational bearing on the amount of deference the Veterans Court owes to the VA's benefit of the doubt determinations. Speaking of statutes, it is also significant that, under the judicial review scheme Congress has crafted for veterans' benefits claims, the Veterans Court is no ordinary appellate tribunal. The thrust of the majority's reasoning seems to be that, as an appellate court, the Veterans Court should do what appeals courts typically do: defer to the lower tribunal's assessment of these case-specific factual issues. But the contrast between ordinary civil litigation and the statutory requirements for adjudicating veterans' benefits claims could hardly be more dramatic. To begin, the institutional advantages that generally warrant deference to trial courts on factual issues do not exist in this context, because the final decision-maker for the VA, the Board of Veterans' Appeals, is itself an appellate body. What is more, the Veterans Court is an Article I tribunal that Congress placed within a unique administrative scheme. Such tribunals often develop special expertise that guides them in making complex determinations in a specialized area of the law. And that is particularly true of the Veterans Court, which regularly reviews case-specific raw material in veterans' cases. This feature distinguishes the Veterans Court from Article III appellate courts because it gives that court the experience and expertise that enable it to make empirically based judgments on fact-specific issues, such as whether the benefit of the doubt rule applies. Considering these unique features of the Veterans Court and the legal landscape in which it operates, there is good reason to believe that the Veterans Court is actually better suited to resolve the approximate balance inquiry than the VA itself. This is especially so given the need for fairness and consistency in the application of the approximate balance standard. Thus, even though review of the VA's approximate balance determination requires applying a legal standard to a set of facts, the Veterans Court is well equipped to do so, and de novo review of the VA's determination best promotes the sound administration of justice. In concluding otherwise, the majority minimizes the singular characteristics of the review scheme at issue and disregards Congress's choice to task the Veterans Court with ensuring that the VA complies with the benefit of the doubt rule. Finally, because Section 7261A unquestionably authorizes de novo review of questions of law, the majority contends that applying de novo review to the VA's approximate balance determinations would render subsection B1 superfluous. But that reasoning assumes that it was always clear that an approximate balance challenge raises a legal question, an assumption belied by the very holding that the majority announces today. Quite to the contrary, before Congress enacted subsection B1 to require that the Veterans Court take due account of the VA's benefit of the doubt determinations, that court, erroneously, in my view, reviewed benefit of the doubt challenges with deference. Properly understood, subsection B1 accomplishes the clear and important mission of abrogating the Federal Circuit and Veterans Court cases requiring such deference. The majority simply ignores this point. In response to complaints that the Veterans Court was not doing enough to ensure that the VA was, in fact, giving the benefit of the doubt to veterans, Congress inserted into a demonstrably pro-claimant administrative scheme the requirement that the Veterans Court take due account of the VA's application of the benefit of the doubt rule. The reading that the majority adopts today reduces that provision to a rhetorical flourish and all but ensures that the Veterans Court will continue rubber-stamping the VA's application of the benefit of the doubt rule. If the majority's holding is correct, then Congress went through an awful lot to achieve relatively little. The far better reading of this statute, one that fully comports with the text, structure, context, history, and purpose of the provision Congress wrote, is that the Veterans Court must review without deference the VA's approximate balance determination, and thereby fully assess that agency's compliance with Congress's commands. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.